Hi, my name is Shaun Brown. I'm a lawyer with nNovation LLP, and we're a law firm that's based in Ottawa, Canada. My practice focuses on privacy and online marketing. I'm here with André Leduc, who is the manager of the National Anti-Spam Coordinating Body at Industry Canada, and we're here to talk about Canada's anti-spam legislation, or CASL. This session builds on a couple of previous video sessions that were put together by MAAWG. This session is intended to cover updates that have happened since the last video session. Specifically, we're going to talk about the Industry Canada regulations, which were passed in December 2013. So you're encouraged to review those previous videos before watching this video, as it will make this session more helpful. As you're likely aware, CASL was passed back in December of 2010. The Canadian Radio, Television and Telecommunications Commission, or CRTC, which is the enforcement agency under the legislation, finalized its regulations in March of 2012. We've been waiting on the Industry Canada regulations for a few years now, and now that they're finally here, the waiting is over. When these regulations were finalized, Industry Canada also announced when CASL would actually come into force. Most of the law, including the rules that apply to the installation, the sending of commercial electronic messages, come into force on July 1st of 2014. The rules that apply to the installation of computer programs come into force on January 15 of 2015. And finally, the private right of action under CASL comes into force on July 1st, 2017. And so now André is here to tell us about the Industry Canada regulations. And I think to start off, if you could just tell us at a high level what the Industry Canada regulations are all about and why they're important, that'd be great.
Well, the regulations define certain concepts that appear in the law itself. So things like personal and family relationship are defined in the regulations. And it also provides for exclusions from the application of the law, in some cases with reference to the requirement for consent prior to the installation of a computer program or consent for sending commercial electronic messages.
Okay, well maybe we'll start off with some of those definitions then. We see definitions for personal and family relationships. So if you could explain what those are and why they're relevant under the law. So
Section 65C in the Act provides an exclusion for sending commercial messaging to family and personal relationships or friends. The state doesn't have any place to regulate those activities, so we exclude them from the Act, and now we've defined personal relationship as two people who have the sharing of interests, opinions, etc., and have had voluntary two-way communications previously. And the idea here is that what would a reasonable person deem to be a close personal relationship? So it's a fairly broad exemption as long as you have close friends and family. For family, it's slightly different. You have to be related through marriage, common law, or any legal parent-child relationship, and again have to have had voluntary two-way communications previously. Sometimes we get questions about, well, what about family members who don't necessarily fall into the definition of family relationship? In those circumstances, it's hard for us to imagine a scenario where they would be family members and would not fall into the personal relationship category. So we feel that it covers the waterfront, so to speak, in terms of friends and family.
So the point being that if a certain type of relationship, for example, a sibling relationship, which might not be explicitly captured by family relationship, would be captured by the personal relationship.
That's right.
Okay. Following up on that, there are a few other definitions, and maybe you don't have to really explain them in detail, but provide a bit of context for the definitions for membership, club, association, and voluntary association. Why are they in there?
So the Act provides for an exclusion for the requirement for consent to send commercial electronic messages for non-for-profit and charitable organizations. But the Act didn't go into detail about what is a membership in one of these not-for-profit organizations. So the regulation basically deems that if you satisfy the membership requirement of an organization like an amateur athletics association or a club, a charitable group, etc., that you're provided deemed consent or implied consent to send messages to that group of individuals. And there's just one exception there, is they all have to be non-for-profit. except for the promotion of amateur athletics in Canada.
Okay, so getting to the real meat of the regulations, they introduce a number of new exclusions to the legislation. So can you tell us a bit about what these exclusions are and why they're included in the regulations?
Well, the Act is meant to build trust and confidence amongst consumers and businesses to engage in commerce and business in the online marketplace. We didn't want to have the Act interfere with messages that are sent within a business. So in some circumstances, it could have been construed that messages sent within a firm might be CEMs and might require consent. That's no longer the case. Messages that are sent between businesses that have an ongoing business relationship, and those messages relate to the person's business roles, functions, or duties. So basically relate to the reason why the businesses share the relationship. You don't need consent, and the Act will not apply to those messages. An interesting minor mistake that we made with the legislation in Section 6.5 exempts requests and inquiries made to businesses. So those can't count as CEMs, but we forgot to exclude responses to those requests. So the regulations provide an exclusion for when somebody asks you about your product or service, you can respond to them. You don't have to worry about following the requirements of the Act.
So just to be clear, that gives you an exclusion to respond to that specific, for example, complaint or inquiry. That doesn't give you an exclusion to simply start adding them to your broader promotional email marketing list.
No, the requirement there would be that you would have one of the other 4 forms of implied consent or express consent.
Right.
They also provide an exclusion for messages sent to enforce a legal right or a pending legal right or juridical or legal obligation. These would be things like debt collection. So clearly, you know, if you owe a debt to a financial institution or to a company, they want to be able to contact you, and you can't unsubscribe from those types of messages. The regulations also provide for an exemption for messages that are sent over closed proprietary networks. So an example of this would be you have a bank, you do your online banking. Banks tend not to send emails over those public internet networks to your private email account. What they do is when you're in your online banking session, they'll have a portal there where they send you commercial electronic messaging through that portal. It's consistent with the Act because we don't want people to be defrauded in the online environment. And the banks will not need to follow the rules of CASL when sending in that environment. The caveat is that it has to be a one-way system, so normally you can't respond to the bank using that email platform. So it's got to be closed proprietary. I know who's sending me the message there, and I can't respond to them, so it's not a two-way vehicle. The other exemption is for messages, commercial electronic messages that are sent on platforms that have the ID and unsubscribe readily available on the interface. So it's available on screen. I can see a person's profile, click on it. They would meet the ID and unsubscribe requirements when I click on that profile. Why would they be required to include the ID and unsubscribe in every commercial message sent on that platform? So an example here is I interact with a business on BlackBerry Messenger. I can see the business profile at the top. It's on screen every time that we're exchanging messaging. And it would be needlessly redundant for them to include the ID and unsubscribe. So there's an exception for the requirement to have the ID and unsubscribe in those types of messages, as long as it's met on the platform.
Because you would be able to, for example, just withdraw from their particular group.
That's right. So you know who's sending you the message. It meets the requirements for who is sending me this message and how do I unsubscribe from these messages. Next is messages that are sent from Canada to foreign states. So businesses complained that they would be set at a competitive disadvantage. And again, we're trying to grow the online economy, not diminish the online economy. So what we do is there's a permission under the regulations that when you send to a foreign state, CASL doesn't apply as long as you're compliant with the law in the foreign state, and they have to be listed in Schedule 1. There's 120 countries there listed, and should you not be compliant with the law in the foreign state, CASL will apply. And if they're not listed in that list of 120 countries, CASL will then again apply. So we don't want to permit spamming from Canada, but a lot of other countries, Canada's late to the game in terms of having anti-spam legislation, and it would be complex. So, you know, if the rules are slightly different in Australia than Canada, we saw a future where we could have conflicting requirements about identification, for example, where they say, in Australia, you must not have a physical address in your commercial electronic messaging, but in Canada, we require a physical address, and then we would say Canadians can't send commercial messaging to Australia anymore. So we provided this exclusion under the Act.
And as I understand, there's somewhat of a reasonableness test built into that specific exclusion, so maybe you could explain that.
Yeah, the people have to basically reasonably believe that the message is going to be sent to that jurisdiction and it's lawful in that foreign jurisdiction.
Okay.
So they're not expected to know exactly where everybody is at all times. It's a reasonable expectation again. Lastly, there are two exclusions, one for charities and one for political parties. So charities, the Act will not apply to messages sent by registered charities in Canada for the purposes of, and the primary purpose of the message is to raise funds for that charity. So charities have an exclusion there when they're engaged in fundraising. And political parties and candidates and organizations are also excluded from the application of the Act when they're raising funds for the organization or for candidates.
Great. Can you explain what the referral exclusion is all about?
So we provide an exclusion and an allowance to send a single message to follow up on a referral. So if I have an agent that I'm using and I have a friend who requires an agent, I can refer this person to the agent. They get to send one single message. The kickers here are that if I'm going to refer somebody to an agent, I have to have an existing business, an existing non-business, a personal or family relationship with the agent, and I have to have those same relationships with the person I'm referring to the agent. And the agent has to provide my name, full name or ordinary name, full legal name. So it would be André Leduc gave me your electronic address to send you this message. I'm following up on that referral. The difference between, and there's a minor difference between the first time we put in this exclusion and now, is it can be an individual being referred, it has to be an individual providing the referral, but ultimately it can be a legal person. So these would include businesses. So I could refer you to a company, and the company would be permitted to send you. And that was designed to address things like online gifting. Whereas if I wanted to give you a gift in the online marketplace, and I was doing so through a referral, that company needs to be able to send you a message.
Okay. CASL specifically contemplates scenarios where somebody may put together their own list for later is going to be shared or sold to a third party. This is commonly referred to as the unknown third parties. In the regulations create specific rules around how you can actually use consent or build and use a list, which is later going to be shared. Can you explain what those rules are and how you can comply with those rules?
So a company can develop a list of consents in different ways. I can get consent to send commercial electronic messages from my company. I can also get consent on behalf of known third parties. So here are 3 partner organizations. Do you consent to receiving commercial electronic messages from them? And you can provide your express consent for that. And then lastly, I'm going to have future partners. I don't know who they are yet. But you can get consent on their behalf to send you messages as well. And the idea here is for affiliate or points-related programs. So I'm in a coupon group. Well, we don't know that 6 months from now there's going to be a new toothpaste company that's coming on board, and you still want to receive those coupons from that toothpaste company. So it permits that. The regulations, however, require that any consent used to send a message must be available to be withdrawn on every message. So if that toothpaste company sends somebody a message and they withdraw consent, it's the requirement that the toothpaste company informs the company that got the consent in the first place and shares the fact that this individual has removed their consent. So none of the other third parties can use that consent to continue sending commercial electronic messages in future, because there's only one consent there. So you can't just give it away and then not manage the consent afterwards. You have to continue to manage the consent and work that into the contract so that when person A removes their consent, it's removed from the entire list. Now, the question that we get a lot is, do we have to have them land on a page that has a number of different consents? No, the minimum requirement is that any consent provided must be available to be withdrawn. But you can have them land on a splash page that says, do you not want to get this type of coupon anymore, this type of coupon, and so on and so forth, so that you can keep consent for certain categories of messages and then lose it for others. It's really about providing the customer the preferences that they desire in terms of the messaging environment with that company.
Okay, so that to me suggests that anyone who actually wants to be able to build and share lists with unknown third parties in the future has to be able to establish some sort of system that allows you to manage that unsubscribe mechanism across holders of that or users of that list.
That's the requirement, because if other third parties continue to send to the individual who's withdrawn their consent and would normally want to use that unknown third party consent, they would now be liable for contravention under the Act.
Okay. And finally, there are a couple of new categories of computer programs that are essentially excluded from the requirements that apply to the installation of computer programs. So can you explain these exclusions?
So for telecommunication service providers, which is defined very broadly in CASL compared to where you would see it normally being a common carrier, like in the United States would be Comcast or Verizon, in Canada would be a Bell or Rogers. It's defined more broadly than that. So it's any company or group of companies who together or apart provide a telecommunication service. So an example I always use is, you wouldn't normally think of General Motors as being a telecommunication service provider, but when they're engaged in OnStar, they are for the purposes of this legislation. And the Act provides two exclusions for TSPs in that broad group again. One is if they're updating or upgrading the network to protect it from a security threat. So for security-based purposes, they can update or upgrade all or part of the network to protect the network. The other one is when they're doing an update across all of the network or part of the network. So imagine, if we mentioned Comcast already, if they have to do an update across the TV set-top boxes for the cable systems, well, they're not going to wait for 3 million people to provide consent before they provide that update. So when you're doing it on a network-wide basis, even portions of a network where it's not reasonable for you to get consent from everybody that's on the network to be able to do the update or upgrade, they're providing an exclusion from that type of activity. And finally, not limited to TSP, so this is available to any legal person. They can update or upgrade a computer program when it's necessary to correct a failure in the computing system, software, or hardware. So if they have to fix a problem with it that would, the person would normally expect the program to be running, they're permitted to install without the requirements for consent again.
Just to be clear, are these complete exclusions from the legislation, or are there any conditions around relying on these exclusions?
No, the idea here is that the people who are receiving it are deemed to expressly consent to that installation unless they have engaged in an activity that would normally limit it. So, if I no longer am a client of Comcast, they wouldn't be able to update my set-top box. I took a step towards trying to unsubscribe or uninstall the program, and I shouldn't be receiving those updates anymore.
Great. Well, that covers the Industry Canada regulations, and again, for more information about CASL, please refer to the previous MAAWG-CASL training videos. Thank you.